and thank you everyone for joining us today for this CLE. Jen and I have presented this information a couple of times, and it's our hope that it is as resonant with you as it is with most of the audiences that hear this. We've all participated in a number of CLEs, and we are very proud to present some information that we think will be pretty impactful on the group. So we're going to be taking a look at access to justice and a spotlight on the fair practice solutions and ways that we can solve this problem. Before we get into how to solve the problem, we first have to understand what it is, right? So taking a look at access to legal representation, if we just jump back a couple of decades and look at the history of this issue, back in the 1970s, 99% of people that needed legal representation were able to acquire it. We like to expand this to say legal services. Obviously, not everyone needs full representation. This would include estate planning, just legal needs that are being met. And so in the 70s, we are an academic profession. We had a 99% grade, right? We had a A+, almost a perfect grade. We were helping as many people as we possibly could. And that's the purpose of our profession, right? We are public servants. We're a very necessary part of the fabric of a democratic society. And in the 70s, we were fulfilling that role. Now, I also like to point out, anytime there's, we're in a capitalist society, anytime you're having this level of success in a profession, complacency isn't usually the direction that industry goes. Things usually become more aggressive. Whenever it's a very positive business environment, people tend to increase their retainers, increase their hourly rates, increase their flat fees, without ever really checking back on how those things have impacted access to justice and impacted people's ability to acquire representation. So now we fast forward 50 years. These are the current numbers. So we went from a 99% representation rate to 22%. So again, sticking with the academic analogy, we're getting an F-. We're all in summer school, we're all in remediation. And this is the number that really pops out at people, because in our day-to-day lives, in our day-to-day, process of running our practice and helping people, I don't think most of us recognize that the circumstance is this dire, that less than a quarter of the people that need help are getting it. And you can see the impact of this already, right? So 78% of people aren't getting the help they need. The rest of the world keeps moving. These people need help. These people need services. And if we don't immediately, as a profession, find a way to help a huge population of this unrepresented, segment, we're going to have the ability to help them taken away from us. It's already happening. This isn't doom and gloom. The sky is maybe falling. It is. If you look at certain jurisdictions, Michigan is gearing up. They just passed legislation to allow paraprofessionals to represent people and to help in a number of different matters. In Arizona, a paraprofessional, a non-attorney, can go to trial. A non-attorney. So the world is going to keep moving. We're either going to solve this problem ourselves, or the ability to do so is going to get taken away from us, and the amount of work that we have is going to continue to dry up. Another really important aspect of this is, what does this mean for us as business people? This means all of us are chasing this 22%. All of us are chasing these people in this small segment to be able to build our firms, right? The first thing to understand here is why. Why has this number decreased to 22% getting representation? And the answer is just simple income demographics. 22% of the people that need representation are getting it. 20% of the population are high income earners. It can very safely be said that, we're only helping the wealthiest among us. And I think most of the people sitting here watching this would agree that's not our purpose. That's not our function as attorneys. We are meant to provide remedies and help to this entire population of people. So let's dig into this. Let's dig into these income demographics a little bit. 22% of the people are getting help. 20% are high income earners. Why is that correlation something that exists? It's because of how we bill. It's because of how we charge. We have all been indoctrinated into this idea for 150 years that clients can pay large upfront retainers and then continue to pay those large amounts, right? The traditional business model, typically, if you're in family law or some type of civil litigation, most attorneys are now asking for $5,000 to $10,000 up front. And then when that retainer is depleted, one of two things typically happens. Either they have to refill their retainer. There's a refill provision that says, hey, when you're down to 20%, you need to bring that back up to your retainer amount. So on a $5,000 retainer, they now need to come in with $4,000 more in perpetuity, as long as you're handling their case. If it's a $10,000 retainer, that's $8,000 in perpetuity that they have to keep coming in with. High income earners can do that. They make 170 plus in annual income, but the most critical metric here is liquid assets. Remember, we demand large upfront sums of money regularly. So when you look at high income earners, they have $40,000 to $40,000 cash on hand. Doesn't matter how we structure our services. They can afford it. That's not going to be a problem. Low income earners, obviously, they're going to have a hard time acquiring private representation. They have less than $1,000 cash on hand, $52,000 or less in income. When you apply even a modest tax factor, that's like $3,600 a month, they are barely surviving. We have public services that are available for this population most of the time. Pro bono, legal aid, law clinics, court appointments. We do have things that are trying to service this population because economically they're having a difficult time actually retaining private representation. That leaves 50% of the population. 50% of this population are middle class, working class Americans. Why can't a person with a nice paying job afford representation? That's the challenge that we're trying to overcome and face at Access Legal. Our position is these people can afford legal representation. They make between $5,000 and $15,000 a month. A lot of the people in this meeting fall into this category. The people that we interact with, that we associate with, fall into this category. Teachers, accountants, they make good money, they drive nice cars, they live in $350,000 homes. How are they able to do that, right? How are they able to do that with $1,000 to $4,000 liquid assets? They do that because almost every other industry has evolved to meet people how they get paid. And so, yeah, you want to buy a vehicle, you put a down payment, then you pay monthly payments into that for a number of years. You want to buy a home, same type of thing. The legal industry is one of the only industries where we have not evolved. We say to people, hey, I need $5,000 to get your case started. Sometimes, a case that'll take 2 years, we're still demanding those types of fees up front. And don't get me wrong, there are times when you have someone in the high income strata that comes in and they have 2 businesses and 10 properties and a number of different things that they're in conflict over. Yes, you're dealing with a 20%er there, and you often have to approach them with the traditional model because of the cost that's going to come up front, business valuations, appraisals, things along those lines. But This 50% middle class represents 171 million people. And this particular demographic typically doesn't have the same level of complexity and conflict because their assets just aren't as extensive. So if you have a welder and a nurse, you know, those people make good money. They work really hard, but if they are a household that now splits up, instead of 1 to 4,000 cash on hand, they have 500 to 2,000 a person each cash on hand, right? So what we have developed at Access Legal is a way to service these middle class, working class Americans. That gives you the opportunity to double, triple your revenue, your clients, your client load. And our position on this is, if we can get service to these high income people and these working class people, we're now looking at 70% of the population that we're able to service. And where does most of the funding come from for these low income programs? Most of that funding comes from our IOLTA accounts. So if we look at, you know, an 80% drop in service over the last 50 years, it can pretty safely be said that's an 80% decrease in revenue and clients flowing through people's IOLTA accounts. So if we can double, triple the amount of clients that we can help, we can close this access to justice gap. And incidentally, that will create 2 to 3 times more funding for these programs for the low income earners. And so our solution to help bridge this gap, to help get service to this population of people, is the FAIR practice model. The FAIR practice model, FAIR is an acronym. It stands for Financially Accessible, Innovative Representation. You'll notice nowhere in here does it say discount or cheap. This is not about discounting your services. This is about offering the same fees you typically charge. It's expensive to be an attorney. It's expensive to run a law practice. But the way we collect that money is what determines whether or not people are able to come into our firm and hire us, or whether or not we just have to turn them away. So it is my pleasure to introduce Jenn Johnson to take us through the financially accessible portion of the FAIR practice model.
Thanks so much, James. And I believe we're going to have a poll question coming along here in just a moment. So if you all would take your time to answer that, that would be really good. Okay. Are you all still able to hear me?
Mm-hmm.
Okay, very good. All right, so as we are talking about the FAIR practice model, we are really talking about just a different way to offer the same services that we have always been offering. We're just going to collect our fees a little bit differently. And every time I've had the opportunity to speak with attorneys about the FAIR practice model, many times I would say, there are people who are asking the question like, okay, well, you know, are we sure that we can do this in the way that you're saying that we should be able to do this? Because part of what we'll talk about is limited scope representation and collecting flat fees and collecting fees in different ways. And so people are concerned, you know, is this something that's accepted? So we have taken the approach of going through the rules of professional conduct and making sure that what we are offering does meet our ethical requirements as attorneys. So today, as we're going through the FAIR practice model, we will be kind of sprinkling these ethical rules in different areas as we're talking about this, so that it's apparent to each of the attorneys on this program and anybody who would be offering the FAIR practice model that we are not just following rules that are set before us, but we are actually answering the requirements that our rules place upon us as attorneys to provide good legal services to everyone, regardless of income. This is our calling as attorneys. I bet most of you who are on this call right now today, if we were to ask you, why is it that you entered the practice of law to begin with? Many of you would have an answer that's similar to, because I want to help or I want to make a difference. And so when we are talking about helping and making a difference and meeting our obligations under our rules of professional conduct, we're talking about providing services to people regardless of their income. James and I like to talk about the preamble quite a lot. And, in every one of these presentations, that's one of the things that we like to share with everyone. The preamble to our rules of professional conduct literally say that a lawyer should be mindful of deficiencies in the administration of justice and of the fact that the poor and sometimes persons who are not poor cannot afford adequate legal assistance. And we are called to do something about that. And the answer to that call for us is this fair practice model. So that's the basic part of the rules that we rely on for why we are doing what we are doing. And then we're also going to talk about through this the relationship that we as attorneys need to create with our clients. And so the rules of professional conduct give us some guidance about how we are to be in relationship with our clients. A few of those rules are about competence and how we are required to be competent in how we deal with our clients. Diligence, rule 1.3, we must stay on top of everything. Diligence and competence kind of go together. We need to stay abreast of all of the new technology, and we need to make sure that we are competently representing our clients in a very diligent way. And then communication is also implicated here. We're required to communicate with our clients in a way that they can make informed decisions about their representation. Rule 1.2 is another one that we'll talk about, which is about limited scope representation, or it's called the scope of representation. Rule 1.2c offers the ability for us to limit the scope of our representation so that perhaps people who can't afford a full representation might be able to afford some help as opposed to no help at all. So we'll talk about that as well. And then, of course, Rule 1.5 is about fees. And as we all know, our fees have to be reasonable, and flat fees have been deemed to be reasonable in most jurisdictions, if not all. So, certainly anytime we're talking about fees, we're not giving you specific instructions about what your jurisdiction calls reasonable, but just be aware that if you are charging reasonable fees, then you will be able to implement the fair practice model. And then Rule 1.15, safeguarding client property. We all know this one as the trust account rules, or one of the trust account rules. And so we'll be talking about that as well as we go forward. So all of these will be discussed throughout. All right, so now let's talk about the first part of what the fair practice model is. So again, FA means financially accessible. So what we like to do is to instruct the attorneys who work with us in our network about how to lower your access point and utilize the technology that is available to us today that wasn't available to us until within the last decade or so. And so specifically, we're talking about LawPay gives us the opportunity to automate our payments. It is specifically designed for lawyers so that you have the opportunity to have the money go into your trust account or your operating account. It gives you lots of options on how to do that. But it gives us the ability to schedule and automate recurring payments, which is what makes a lower access point doable. It makes it possible for us as attorneys to say, I don't really need that whole 20 or 30 hours paid up front. What I'd need is enough just to get started. Maybe I need, $1,000 or $2,500 to get started in the litigation. But if I can set up an automated recurring payment that is weekly or bi-weekly, and that starts immediately after you've gotten your initial payment, then you're going to have the opportunity than to have your full fee paid, but you're just having it paid to you over time. And with the automated ability, the ability to automate these recurring payments, then it's not like your client has to make a decision of whether they're going to pay the lawyer's bill this month or not. This would include an authorization where they would authorize you to withdraw from their bank account or to make a charge on their credit card in regular intervals, whatever the fee is that you are going to set for them. So financially accessible, we want to, for full representation, we want to lower that access point so that we're falling within that liquid asset or liquid cash on hand amount. So if you'll remember, for the working class, for the middle income segment, they have between $1,000 and $4,000 in liquid cash at any given time. So if we are saying to them that we need for you to come into our office with $5,000 or $7,500 before we'll even get started, we are automatically outpricing our clients. We're automatically requiring that they go to grandma and borrow money, or that they find another way to come up with the additional money that they do not have. And so this premise is, if we can lower that access point so it falls within that $1,000 to $4,000 cash on hand, and then utilize their good income, they've got good steady income, allow them to pay $250 every 2 weeks or $150 every week out of their paycheck so that they can continue to afford good private legal representation. So we're reducing that access point. We're utilizing automated recurring payments. And the most important part of the automated recurring payments that we have found in our network is, if you will schedule those on the payday of the client, you are doing a great service to your client. I always say, when is the easiest time for us to pay a bill? The easiest time to pay a bill is when there's money in the bank. And so on their payday, if we are scheduling these payments at that time, it's much easier for them to pay us at that time, and then they can continue that on a more a higher frequency than what we typically see. So we're talking about weekly or biweekly as opposed to monthly. And this is how we kind of differentiate ourselves too in the marketplace, because most attorneys, if they're going to bill, they're going to bill monthly, and it's going to be on some arbitrary payment schedule that the law firm or the lawyers select, either the 1st or the 15th of the month, or at the end of the month. And that doesn't take into account the schedule of payment of the client. So right here, I want us to talk about how we can focus on the client as well, because I really do feel like as attorneys, sometimes we're all busy, we're all stressed, we have court hearings, we have lots of clients that we're dealing with, and many times we can get into somewhat of an automatic process as we're dealing with new clients who are coming our way, or prospective clients who are coming our way. And we kind of forget sometimes that we really need to be paying attention to the detail and to the client themselves as a person when they are coming to us. And so we want to know, what is your current income circumstance? What is, how is it that you are getting your income, when and how much, and what would be affordable for you and for your family? So instead of it being about the lawyer and the law firm and when they need to send out invoices and that sort of thing, we like to say, let's flip that script just a little bit and let's talk about what the client needs. Because if we're meeting the client where they are, the client is much more likely to be able to say yes to hiring us in the first place, and they're going to be much more likely to maintain those payments over time when they feel valued. And so it's a very important thing that when we are dealing with any prospective client, that we are putting their needs first. We're paying attention to that. And that is also what we are required to do under the rules, is to, put the client's interest before our own. And that starts with that very first consult when we're talking to them about how they can engage our services financially in particular. All right, so If we're setting the payments on their payday, we're making that a very smooth transition for them, something that they can do. And we want to make sure that we are keeping in mind about how long it's going to take for us to handle this matter. So if we're going to be accepting payments over time, you want to make sure that your fee is paid before you have finalized the representation. So you have to have a timeline of the case in your mind so that you know how much you would need to receive from them bi-weekly or weekly, depending on how they're paid. So let's say we've got a custody case that may take 12 months, 18 months. That's what it would be in my jurisdiction here in Mississippi. So we can say in our minds, okay, I've got 12 to 18 months to collect this full fee for this custody matter. And so what we want to do is make the best estimate we can make about how long the case is going to take to conclude, and we want to make sure we set those payments in a way that we're, paid in full a month or two before the finalization of the representation. This requires that we have an honest conversation with all of our clients about money, what they can afford, and what they need from us as attorneys. So if we can use the technology that is in place, if we set these payments over time up in the way that we're talking about doing on their payday, higher frequencies, lower amounts, then what we have found in our network is there is a 90% collection rate for the attorneys who are setting up these automated recurring payments in this way. And you will have collected your full value of your fee. Nothing about this, as James said just a little while ago, is about discounting fees or pro bono service. This is about how we meet the clients where they are, give them an opportunity to pay for the valuable service that you are offering them, and an opportunity for you to collect your full fee. All right, so another way that we can help our clients and meet them where they are is by being willing to offer limited scope services. Now, this is where we were talking about Rule 1.2 of the Rules of Professional Conduct that allows us to limit the scope of our representation. Number one, if it's reasonable under the circumstances, and number two, if the client gives informed consent. So all that means is we have to be very upfront with the client that, hey, listen, I'm happy to help you for this limited amount of legal fee for these limited purposes. And I need you to understand what that means. So they have to give their informed consent, knowing consent. But when we're offering limited scope or talking about it, we are talking about two different types. We've got what we call an a la carte limited scope, which is like discrete tasks where you might make a call or write a letter, or maybe even review or draft documents and coach the client a little bit on how they could continue to self-represent. So we call that a la carte. Or we have the phase by phase representation, where you might make an actual limited appearance in court for one particular phase. We've been talking about family law. So if we're talking about someone who cannot afford full representation from your firm, they just don't have the money to put down toward that, but they might be able to afford a flat fee of about $2,500 to get them to temporary orders. Then you can craft a limited scope retainer agreement that sets forth, I'm going to represent you for this phase and this phase only. And then you can file a notice of limited appearance with your court. You can find those forms on your court's website to let the court and the counsel opposite know that you are in this only for a very limited purpose. So that would comply with the rules of professional conduct under Rule 1.2. And this is a way that we can, again, meet the clients where they are. We can say, okay, listen, I understand you can't afford full representation right now, but what is the most important timely assistance that I can offer to you? And let's talk about what that is. Again, this requires one of those real eye-to-eye, face-to-face conversations with the client to determine really what they need at this very given moment. A lot of times with limited scope, we're talking about flat fees. Flat fees can offer a lot of predictability for the clients. They can budget for that. And you can also collect flat fees over time. You don't have to have the whole amount up front. just determine what a threshold amount might be, so, to get you started. How many hours you might put in it for, drafting a pleading and then making an appearance in court. What am I going to need to get started? And then immediately start those automated payments weekly or biweekly, so you're keeping up with your fees that way. Again, we have to be very clear with our retainer agreements on this, just to make sure that we are giving, getting informed consent from the client as we need to. Innovation is another part of the fair practice model. So we've just been talking about financially accessible, but innovation comes at the very top. It's like the umbrella that we use in determining how we are going to meet the clients where they are. And I think the retainer agreement is one of those places where we need to be innovative and creative. It needs to be specific enough that the client can read that agreement and understand exactly what it is that we're offering to them for the representation. And it also, just needs to define what that relationship is going to be. So your retainer agreement is very important to help manage any kind of risk you might have for any of the limited scope services that you plan to offer. So another thing that we always recommend is, if you're going to be doing these automated recurring payments, you should have an authorization from the client. Again, a really good, honest conversation with them about what this means. This means that every month or every other Friday, or whatever the frequency is that you're going to be paying, every Friday or every other Friday, I'm going to be withdrawing from your bank account this amount of money to pay for your legal fees, or I'm going to be charging this card this amount of money to pay for your legal fees. And the written authorization is a good way for you to manage risk for your firm and yourself, because you've got a signed authorization that allows you to do that. So that's another very important part of being innovative and of making sure that you're managing your risk of your firm. All right, so we have another poll question going here. And at this point, what I'd like to do is turn it back over to James. He is going to talk about the innovative representation part of the fair practice model, and give you some additional information about that.
Thank you, Jen. I also wanted to hover on something you said really quickly. You were talking about being able to collect and earn the full value of the case. And both the automated recurring payments on full rep and the limited scope phase by phase allow you to do that in a way that we typically don't take advantage of as practitioners. What typically happens to a lot of us is, even if the client can come up with that first down payment, once their retainer is depleted and you demand the refill, the client can't move forward. You have to withdraw from the case and you lose all the future value of the case. So if it's a $15,000 divorce, $12,000 divorce, because of the way you ask for your retainers and your refills, yes, the client is able to come in with $4,000 or $5,000 the first time. The second you demand that refill provision, those income demographics don't lie. People don't have that second installation, that second down payment, that second large sum. They lose their representation. The court inherits a pro se litigant. The attorney loses all future value of the case. So what Jen's talking about here is so important, because not only does this practice model give the opportunity for more people to come in your door, but it gives you the opportunity to find a way to keep them through the duration of their case, to earn the full value of their case. Even limited scope services, yes, by taking them phase by phase, you're allowing them to budget for those things. You're giving them flat fees that are predictable, that they can budget for, they can pay off, they're self-contained, they're not gonna get another bill for $5,000 unexpectedly. So both of these methods allow you to earn the full value of the case, which I just wanted to revisit for 2 seconds, Jen, because I thought that was such an important point.
Very important.
So on to the innovative representation. As Jen had mentioned, this encompasses so much more than just technology. This practice model is not something that was just workshopped in a boiler room to come out and present to you. This has been developed over 20 years. Access Legal has had a number of different names during that time, but we've worked with over 4,000 attorneys, sourced over 2 million potential clients, and we've seen our network generate over $1 billion in legal fees and collected revenue utilizing this model. What we want to do, what we have done over the last 20 years, is aggregate all of that success, going to cities where our most successful attorneys are practicing, putting a microphone in front of them and saying, please tell the rest of the network what you're doing to make this work. So I also want to make that point. We are a skeptical, risk-averse profession. This isn't something that was just dreamt up to come talk to you about. This is something that's been developed for over 2 decades that is proven to be successful at helping this middle class, working class demographic acquire legal services. So, Jen mentioned it, innovation takes many different forms. Right now, I'm just going to talk a little bit about the technology aspect of that, but please keep in the back of your mind, you know your jurisdiction's rules better than anyone. You know your processes better than anyone. This is about taking these principles and finding the places within your own processes, within your own procedures and court procedures where you can effectively offer these types of different services, right? So sticking with the innovative aspect of this, Jen mentioned this practice model wasn't available 8 years ago, 10 years ago. We were all still in that space where we're mailing invoices, asking people to mail in checks. Maybe they can click on a link and pay through the link. Most of you probably have your staff every Friday, or if you're a solo, do it yourself every Friday, reach out to clients and collect money and try to get payment plans paid in. The advent of merchant services, that's the first thing I'm going to focus on, because that is really the linchpin of this entire practice model. No one wants to make any type of shift or change if you're just maintaining the status quo. Most payment plan is kind of a dirty word in our profession, because most of us have the experience of offering payment plans in that antiquated way, where we have a 40% collection rate because we're asking for checks and trying to chase people down. The trade-off here, as Jen had said, this is about having a conversation with your client, and the trade-off is, I'm gonna let you in for a lower amount. I'm gonna let you in for between $500 and $2,500, which no other attorney is gonna do, but we're not gonna chase you. You're confirming that people have jobs. You're taking a card and putting that card down as part of your merchant services. There's a million of them that are out there. LawPay, AffiniPay are always. I know that this is a MyCase sponsored CLE, but I'm still gonna say it is the best product out there. You can schedule payments on their payday. As we said, that is critical. That removes the ability for them to deprioritize us. The reason payment plans don't work is because our matters take too long. So we get people out of choppy water, we get people out of, the frying pan, and then once they feel safe and settled, they start looking around for where else they have a fire that they need to apply that money to. So by putting their payments automated on their payday, you're just saying to them, hey, put this as a set it and forget it, keep that card current, keep your job. You will be able to acquire a high caliber, competent attorney for a very affordable, in a very affordable way. So this is about, like we've said, meeting them where they are, and not only meeting them where they are, but also protecting yourself. By initiating these payment plans on their payday, you're assuring yourself a 90% collection rate, right? 9 out of every 10 of these people are going to actually make it through their payment plan. So it's important to start with merchant services. I always like to make this point also. Merchant services, a lot of times, if you're using these correctly, you're getting rid of the yes, but. A lot of clients that want to enroll don't have their finances secured in that moment. So you get, yes, I want to hire you, but I need to start next Friday. I need to talk to my spouse. We can get this sorted out. With these merchant services, you can usually just schedule that initial deposit. So, oh, Mr. Smith, you want to move forward? No worries. I can schedule you for your deposit next Friday. If anything changes, if you change your mind, I can cancel that. But otherwise, I want you to go to bed tonight knowing that you have a lawyer in your corner. And that line for clients is worth its weight in gold. They are terrified when they come to us. They are up all night. They are afraid to interact with us first, and they're afraid of what's going to happen to them. So if you can give them some of those assurances that you're in their corner, that you are going to be taking care of them, and not make them wait an extra 7 to 10 days to officially sign up, you're going to see a huge benefit for yourself. And again, by utilizing the automated recurring payments, you're going to see your collection rate go way up. And we forget a lot of times as business people, $250 every 2 weeks is $6,000 a year. So if you're handling matters that have longer litigation times, family law, for example, you have 2 working class people that have a custody case, you're looking at 18 months, 2 years. That's $9,000, $12,000 in automated recurring payments over that time. Most of the time, that's going to cover the cost and your fees for that type of proceeding. So very important to get aligned with a merchant service. Along, this kind of suite of services that are available, e-sign capability. We used to have to email a fee agreement and have them sign it and either scan it back to us or something that was cumbersome. Now, while you're in a Zoom meeting with the client, you can draft a fee agreement, at least a general fee agreement on the side, email it to them, have them bring it up, review it in the call with you, and have them sign it right there using, obviously, e-sign capability. Document automation is huge. Jen was talking about, flat rates, being able to increase your effective hourly rate by utilizing doc automation. Of course, you're decreasing the amount of time it takes to actually process the file. And if you're using flat rates and things like that, you're able to very demonstratively increase your effective hourly rate. So using document automation, especially in form-driven businesses, estate planning, bankruptcy, that can be critical to driving up your profitability. Calendar and booking software. Sometimes this goes overlooked, but what it really does is allow the client to schedule with you on their time. We used to be in an environment where if people needed an attorney, they took the day off of work, they put on a suit or a dress, they came into the office, they met with 5 attorneys and, to see who they wanted to work with, and then they chose someone. You now have, a single mom on her second job of the day. She's lying to her boss to go into a bathroom stall and send out a legal inquiry about the fact that dad didn't return the child after this weekend. And that person might not be available during office hours. You might have a difficult time tracking them down with conventional methodology, just having a call center or your staff reach out to them. You need to be able to give them a way to book with you when they're available. So calendar functions are great for that purpose. You can email or text a calendar link, hey, sorry I missed you. Click on this, drop yourself on my calendar whenever you're free. If any of these times don't work, email me, we'll figure something out. That gives them the ability to book it, at a time that's convenient for them. And then a huge part of this, attorney, we hate having our time wasted. So no-shows are a huge issue with consultations, especially virtual ones. Calendaring software most of the time will offer notification services. So you can set it up so that a day before the event and an hour before the event, the potential client gets an email and a text message reminding them of the event, and that drives up your show up rate considerably. And then many client management systems have all of these tools built into one. Obviously, MyCase is an incredibly valuable tool. It has all of these things built into one. The MyPay AffiniPay, or the LawPay AffiniPay function also has like a credit function where you can, say to some clients, hey, if you think that you would qualify and you would rather go in this direction, you can apply for a loan for my fee. And if it's, approved, AffiniPay actually pays you and then collects the money from the client. So there's a number of incredibly valuable features that MyCase in particular offers. And the last piece of this that is important to note is AI-driven tools. And the market is flooded with AI tools at this time. There are so many that it's actually hard to keep up. And so I encourage everyone to continue to explore different, different methods of technology, including AI, that you think could benefit your firm. What I want to focus on is a different aspect of AI that most of us likely aren't considering, and that's how the clients will use AI. For the history of our profession, we have had our expertise and the knowledge of how our profession works kind of behind a wall, where clients come to us, they're unsophisticated in our world, they don't know how the billing works besides what they've seen on TV and movies, and it gives us a lot of leverage and an advantage in that consultation. Clients are going to be able to use AI to shop for us. That is one of the biggest developments that you are going to see. Arguably a larger development than the AI tools that you'll be able to use. Because what will happen is a client is going to be able to assign an AI agent, and they're going to say, please find me a custody attorney in this jurisdiction that can get me started for this amount, that'll work with somebody that's middle class, that will work with this income. They're going to cue that AI to go find them an attorney. And that's really where this fair practice model comes in, is that it helps differentiate your firm in a competitive way. If every other firm is asking every one of their clients by default for a $5,000 to $10,000 retainer, and you are popping up in these searches and from these agents as a fair practice, as a fair practitioner, somebody that executes the fair practice model, it is going to identify that you are someone that's offering affordable, attainable services. It is going to differentiate you competitively and set you apart from all of the attorneys that are just running the traditional business model. And as evidence for that, the one thing that I like to close with, that Jen and I like to close with here, is just an illustration of that dynamic. So Jen and I went to the Equal Justice Conference in San Francisco this year, and we were watching a presentation by Legal Link. They do great work. They offer something, if I'm not mistaken, Jen, it's called Legal First Aid, I believe. Yep, Legal First Aid. It's an AI tool that they utilize that helps pro se litigants find resources in their area. But the users of that service are also prompted for a survey, and they surveyed a number of different people, and they've actually run this survey twice. And very interestingly, if you think about all of the different nouns and adjectives that could be used to describe how our profession works, it's very surprising that in both word clouds, both of their surveys, the participants overwhelmingly felt that our profession is unfair. And we had already developed the fair practice model at this point. This was just very affirming for us that if you're in this marketplace, clients view what we do and how our profession operates as patently unfair. So if they are using AI agents to shop for them and to find attorneys for them, the fair practice model being identified as a fair practitioner is something that's going to stand out to them and hopefully break through that trust barrier.